Hello and welcome to SRIRAM's IAS. Welcome to this class. आपका अभिनंदन है और I hope you all are doing fine. You are doing best in your preparation for your upcoming examination on 25th of May 2025. तो current affair forms a very important part of your preparation. Indian polity forms a very important part of your preparation. Around 15 to 20 questions in prelims exams are asked from Indian polity. And if you see, कहीं ना कहीं अगर आप देखें तो करंट अफेयर्स में जो चल रहा है वहाँ से क्वेश्चंस निकाल के पूछे जाते हैं. तो इसी वजह से अपन ये सीरीज़ लेकर आए हैं. श्रीराम्स आईएएस आप लोगों के लिए ये सीरीज़ लेकर आया है जिसमें 50 मोस्ट इंपॉर्टेंट टॉपिक्स विल बी डिस्कस्ड फॉर योर अपकमिंग एग्जामिनेशन. दिस विल बी डन इन ऑल दी सब्जेक्ट्स, नॉट ओनली पॉलिटी. द नेक्स्ट फैकल्टी फॉर इकोनॉमिक्स, एनवायरनमेंट एंड अदर सब्जेक्ट्स विल ऑल्सो कम अप विद देयर रिस्पेक्टिव क्लासेस. तो यहाँ से अपन चालू करेंगे इंडियन पॉलिटी को लेके. एंड दिस इज अ वेरी इंपॉर्टेंट सब्जेक्ट. इट कैन मेक और ब्रेक थिंग्स फॉर यू. If you prepare this subject really very well, if you prepare the current affairs for polity really very well, it is going to help you a lot. Think about the situation कि 20 questions अगर आपसे पूछे गए हैं prelims examination में और 20 के 20 अगर आपने सही कर दिए तो 40 नंबर दिलवाता है वो. It is very important. So please pay attention here to what I am doing, what I am saying, and let us study together the most important topics of Indian polity. अगर predict करा जाए तो इन टॉपिक्स में से there is a high probability that questions can be asked. So be with me, and if you have any question you can ask me directly. So I am Mayank Bharadwaj presenting this Indian polity class. This is the topic number 1. Let's start the class. So the Lieutenant Governor, gentleman is the Lieutenant Governor, Honorable Lieutenant Governor of Jammu and Kashmir. इन्होंने क्या करा है? He has removed 2 employee of the Jammu Kashmir services. अब क्वेश्चन यहाँ पर उठता है, can the civil servants be removed? So the protection has been given under Article 311 in the Constitution for the protection of the civil servant. There are several immunities which are given. So it is a very important Article 311. You should pay attention when you are preparing for it. You are also going to become a civil servant. So it is also important for you to know what is Article 311 and how it is different from Article 361. This is another very important article which although does not give protection to the civil servants but gives protection to the president and governors. We are going to see this article which is going to come later on. So this was one of the news of the current affairs which we are going to study. So Article 311 is a very important part when it comes to the civil services and the establishment of civil services. This gives certain protections. If a civil servant has to be removed, there has to be a procedure which should be followed. They cannot be removed on the whims and the fancies of the executive. सबसे important चीज, कोई भी civil servant अगर आपको remove करना है तो वो उस authority से नीचे की rank वाला इंसान remove नहीं कर सकता जिसने उसे appoint किया है. For example, a civil servant has been appointed by the honorable governor. तो उसको रिमूव करने का पावर गवर्नर से नीचे की रैंक के अधिकारी के पास नहीं है. ओनली द गवर्नर कैन रिमूव द पर्सन, द सिविल सर्वेंट. ये सबसे पहली शर्त है. दूसरी शर्त, इफ द पर्सन हैज टू बी रिमूव्ड देन it is very important to communicate to the person, to communicate to the civil servant the grounds on which the civil servant has to be removed. ये आर्टिकल 22 जैसा लग रहा होगा आपको. Right against arrest and detention, where a person is arrested, the grounds has to be communicated. He should be given the opportunity to represent himself and presented in front of a magistrate within 24 hours. But this is a different article. That is the right which has been given to a person who has been arrested. Right against arrest and detention, that is a different thing altogether. Here it is a different thing. 311, when a civil servant is removed, there shall be a procedure which should be followed. It cannot be done arbitrarily. Civil services, today is Civil Services Day. Civil services forms the backbone of the whole governance structure of the country. It is the heart of the governance structure of the country. And if civil servants are removed arbitrarily on the whims and fancies of the political class, then what will happen? How will the country survive? How will the governance work properly? So, it is very important to follow the procedure. What is the procedure? Simple. On what basis, on what ground the civil servant is removed, that needs to be communicated to the civil servant. That is the first and the most important one. Second, he should be given the opportunity to represent himself, to defend himself. But exceptions भी हैं. क्या exceptions हैं? अगर सिविल सर्वेंट को निकालना नेशनल सिक्योरिटी के फेवर में है, तो सिविल सर्वेंट को बिना इंक्वायरी, बिना इन्वेस्टिगेशन भी निकाला जा सकता है. So there are several exceptions which are given. So these exceptions are very important. Okay. In the favor of national security, if the national security demands, the civil servant can be removed. Then, if the employee is convicted of a criminal offense, if there are criminal charges against the person, against the civil servant, then he can be removed directly. That is the second exception. And the third one is, where holding an inquiry is not practical. Let's say the person is absconding. He did something and he is nowhere to be found. In that situation, the governor or any other senior authority cannot hold an inquiry against him. So the person can be removed directly. So there are also exceptions given, but at the same time, there are also immunities given. Let's move to the second important topic. Governor of West Bengal has been charged, not charged, sort of, they cannot be charged. We are going to read Article 361, but a woman comes up and allegedly said that he has assaulted her in the Raj Bhavan. So there is something called sovereign immunity which is provided to the governors and the President of India under Article 361. What is Article 361? It originates from a very important convention or from a very important saying of the Commonwealth then that this Rex non potest pecera, that simply means the king can do no wrong. King is a sovereign body. Similarly in India, if you see President and the governors of the states, the lieutenant governors of the union territory, they all are sovereign posts. We are following the common law as well as is practiced in England. So we have taken up examples from that country regarding so many things, and one of the thing is about the governors. There is immunity provided to the governors and the president under Article 361. Okay, they cannot be treated like a criminal when they are sitting on the post. No civil charges can be initiated against them. Civil charges cannot be initiated against them. Criminal charges also cannot be initiated against the president and the governor when they are there on the post. After their retirement, the criminal charges and all these charges, the civil charges, they can be initiated. The proceedings can be initiated after their retirement, but not while they are in service. It is very important for us to understand. That is what is called sovereign immunity, which is provided to the president and which is also provided to the governors under Article 361 of the Constitution. They cannot be arrested. No criminal charges, no civil charges against them. So in one or the other way, this is also against the civil liberties. If think of a situation where a crime has been committed or something which has happened in the recent case of the governor, honorable governor of the West Bengal government. What about the person who is at the receiving end? Are they getting the justice? So this is the debate. Civil liberties on one hand, the fundamental rights of a person on one hand, the infringement of the fundamental right of the person by the governor on the other hand, and at the same time, the governor has the immunity. So is this just? Is this fair? That is the question. But that is the question for Supreme Court and the Parliament to decide. For us, what is important from the point of view of examination is Article 361. You must read it. It's very important. Moving on to the next important topic, Article 329B. So elections in India are controlled within the Constitution from Article 324 to 329. These are very important article pertaining to the elections. 324 talks about election commission, compositions and power of election commission, and how the commissioners and chief election commissioner is appointed and removed. So what is 329B? There are several things in the constitution, there are several situations where the court must not interfere. For example, inside the proceedings of houses of parliament, there is no role of Supreme Court. Everything which is done inside the houses is taken care by the speaker or by the chairman. Okay, so there are other arenas also where the court must not interfere, and one of such arena is the election process. For example, an election process is going on in your state, or a national election is going on, the Lok Sabha election. And what if you go to the Supreme Court or to the High Court and file a writ petition against the election process? Now that is not allowed. जब इलेक्शन का प्रोसेस चल रहा है, उस बीच किसी भी तरह का पिटीशन to stop or halt the free and fair delivery of elections is not allowed. Everything regarding election, if you have to go to the court, if you have to move to the court regarding any practice which you think is not fair, must be done through an election petition after the election process is over, not during that. So in one of the case, the Election Commission has invoked Article 329 and it said that judiciary must be out of the election process according to Article 329. So this becomes a very, very important part of our examination process. So electoral process has to remain uninterrupted. There shall not be any kind of interruption in the election process. This is a very, very important thing which you must understand. Rest of the things are taken care by the Representations of the People Act 1950 and 1951. 1950 talks majorly about the election process before the election, and the Representation of People Act 1951 is all about, you know, the provisions of elections, during the election and after the election, whatever which may come, any thing for which you have to move to the Election Commission of India can be taken care under these two important acts. Moving on, so what is important here? Article 329B. You must remember Article 324 to Article 329, the election process in part 15 of the Constitution. This is very important for your examination. Pay attention to this. Moving on. State can't alter the scheduled caste list. This is very important. Now, Article 341, the subcategorization, you know. So what has happened recently, the Bihar government wanted to include Tanti Tantwa caste in the list. Now, every state have some or the other scheduled castes. The scheduled castes which are there in Bihar will be different from the scheduled castes which are there in Punjab, and will be different for Telangana. Okay. So who makes these lists? Who prepares these lists? The list is prepared under Article 341. The list of all the scheduled castes, okay, is prepared by Article 341 by the President of India in consultation with the Governor of the state. So with the consultation of the Governor of Bihar, one list will be prepared for Bihar. Then with the consultation with the Governor of Punjab, the President is going to make another list for Punjab, and similarly for other states. Okay. And if any amendment has to be done in that list, means adding a caste or removing a caste from that particular list, it shall not be done by the State Legislative Assembly. It has to be done by the Parliament through law. So it is the President who prepares the list with consultation with the Governor. It is the Parliament which excludes or includes a particular caste in that list. State government does not have any power to include or exclude the castes from the list. It cannot amend the list. So the step taken by the Bihar government does not hold. It is against the Constitution. But a recent judgment of the Supreme Court talks about the subcategorization. Now that is a power which is extended to the state governments. Then that subcategorization of those castes can be done. For example, let's say if there are 59 castes in Telangana, all these 59 castes are treated as one homogeneous category. and 15% reservation which is given to the scheduled caste in India. If you know, OBC are given 27% of the reservation in employment and in education. SC is given 15%. ST is given 7.5%. So this 15% reservation which is given to the scheduled caste is given to these 59 castes which are in the list which is prepared by the President of India. Okay, and this is treated as one homogeneous category, and this 15% is applied here. But it is important for us to understand that the castes which make into this list are not equal. Many of them are socially and economically superior to the other castes. And all the benefit of these are garnered by the socially and economically benefiting castes or advanced castes. तो इस 59 castes में से those castes which are at the bottom does not get any kind of benefit of the reservation policy. And for that reason, subcategorization is one tool where you can target the reservation policy and also help people who are very much marginalized and downtrodden. So these 59 castes, let's say, can be divided into 3 categories. Each of these categories would be getting some amount of reservation. Okay, let's say this is given 1%, another one is given 5%, and the last category is given 9% reservation. In total, this is 15% reservation. So this is what is called the subcategorization. Now, states are empowered by the Supreme Court to subcategorize the caste. Okay, but they cannot add or subtract any caste from the list which is prepared by the President of India with consultation with the governors. Moving on to the next topic, PM Modi is talking about UCC. Under Article 44, there is a mention of UCC. It's a very important topic, Uniform Civil Code, Article number 44 of the Constitution of India. This is one of the directive principles of state policy. So what is the basis of Uniform Civil Code? There are essential practices of every religion. Okay, every religion have its essential practices. But some of the practices of every religion are of the secular nature. What are those practices? Marriage is one of them. Divorce, another one. Adoption of child. Inheritance, okay, succession. All these are secular practices. So the Uniform Civil Code tries to make same law for all the religion pertaining to these secular practices. Okay, so that is what is Uniform Civil Code. You must understand, same kind of law for all the religion. It is not trying to change the essential practices of one religion. That is not going to happen. The essential practice of the religion is going to remain intact. Article 25 comes into play here. But the secular matters revolving around inheritance, revolving around succession, marriage, adoption, all these things are very secular in nature, and similar laws can be made for them, irrespective of the religion of a person. That is what is Uniform Civil Code, and the government is trying to make a Uniform Civil Code. But there is also criticism of Uniform Civil Code. What is the criticism? That instead of making a single law for all these secular practices inside the religion, you should try to change, or you should try to amend the personal laws in such a way that it gives more civil liberty to the people. So that is the criticism which is given against the Uniform Civil Code. But in one or the other way, it is the top priority of the government to bring a civil code, a uniform civil code in the country. So this is very important, and you must understand. There are several provisions which is given. While the Supreme Court has emphasized the need for UCC in several rulings, example Shah Banu case, the Law Commission of India suggested reforming personal laws instead of full uniformity. Okay, so this is what the criticism was, and this is what the alternative which has been suggested by the Law Commission. Okay, so pluralism is one of the basic tenets of the culture in India. President Murmu rejects mercy plea of Red Fort attack case convict. So under Article 72 of the Constitution, several rights has been provided to the President. Similarly, these powers are also provided under Article 161 to the Governor of the state. So under Article 72 of the Constitution of India, the President of India can grant pardons, reprieves, respite, remission, and can commute the sentences. What kind of sentences? If it is a death sentence, the President can pardon the death sentence, but a governor cannot pardon the death sentence. You must understand this. The President has the power to pardon, reprieve, respite, commute, or remit any sentences which are given against the laws of the Union. Means all those, laws, all those punishments which have been given to the convicts, which comes under the jurisdiction of the Union government. There the President can invoke its power under Article 72 regarding the pardon, reprieve, respite, remission and commutation of the sentence. That can be done by the President. Similarly, when it is the matter of the state jurisdiction, the governor of the state can also do similar kind of functions under Article 161 of the Constitution. So this is important for your examination. You must remember, you must know this information very clearly. Okay. Now, this power is not exercised by the President or the Governor on their whims and fancies. It has to be done on the aid and advice of the Council of Ministers. That is what Article number 74 says. It has to be done on the advice of Council of Ministers. If the President has to pardon somebody's death sentence, then President cannot do this on his own. He does it on the aid and advice of the Council of Ministers. Now, why this power under Article 72 or under Article 161 has been given to the President and to the Governor? To correct any judicial incorrectness. If some judicial misconduct has happened, or judiciary has been wrong in awarding the sentence of life or through court martial or offences against the union and the state, then to correct that judicial mistake, this power has been given, and also to show compassion. There are many cases where the President and the Governor has shown compassion towards the person who has been convicted. So, to remove the judicial mistake and to show compassion, this power has been extended to the Honorable President and the Governor. It's important, you must remember this. Neuro Rights and Emerging Technology. See, under Article 21 of the Constitution, there are many rights which has been included. Article number 21 has become a mammoth article, right to life and personal liberty. Especially after the Menaka Gandhi case, so many things has been included under Article 21. Right to life and personal liberty. When it says life, the life cannot be only animal existence. It should be dignified life, and for dignified life, many things are important. Clean environment is important. Education is important, which has also been included in the separate article, Article 21A, which is very important. Similarly, bodily integrity is important. A woman, whether should keep the child or abort the child, that is the right of a woman, that is bodily integrity. In a similar fashion, a new kind of right is emerging. They are not written anywhere, but surely that is going to make the, the jurisdiction of Article 21 even broader. What kind of rights are these? These are neuro rights. So, neuro rights are proposed category of human rights. They are not in existence as of now, but they are proposed category of human right which protect the cognitive liberty and mental privacy. These are very important. Cognitive liberty and mental privacy with personal identity. Of course, personal identity is very important. It comes under right to privacy. Right to privacy also has become a fundamental right under Article 21 of the Constitution. So there are several laws which are there to protect the cognitive liberty and mental privacy in India. One of them is the Digital Personal Data Protection Act of 2023, Mental Health Care Act of 2017, and the Information Technology Act of 2000. So the judiciary has indirectly addressed these cases in the Puttaswamy judgment, which is the right to privacy case. It's important, okay. So there is also one case which talks about involuntary narco analysis, giving sedative to a person. वो एक बेहोश जैसी स्थिति में एक आदमी एक इंसान आ जाता है नार्को टेस्ट में, and then it is presumed that whatever person is speaking is the truth, but it has to be done after taking the consent of the person. It cannot be done involuntarily. This was said by the Supreme Court in one of the cases, Selvi versus State of Karnataka. This also becomes a very important part of bodily integrity and mental privacy. Okay, cognitive liberty, that you are giving sedative to a person and making him, fall asleep or in whatever unconscious state and then trying to extract. This is against the mental privacy of a person, and if until the person is giving the consent, that must not be allowed. And freedom of thought. Now, thought definitely originates from mind. It has a direct connection with mental privacy and cognitive liberty. So, thought is also the part of speech and expression. So, cognitive liberty and mental privacy does not only become an important part of Article 21 of the Constitution, but it also becomes a very important part of Article 19 of the Constitution, where freedom of speech and expression has been given to the citizens of the country. Moving on. So, there were several political problems in Haryana, and the governor has asked for floor test. Now, what is floor test? In India, we follow the parliamentary form of government. That is a responsible form of government, where the executive is responsible to the legislature. Individual ministers are responsible to the legislature, and the Council of Ministers as a whole is also responsible to the legislature. So how to keep executive responsible? There must be some instrument, there must be some tools. And one of the tool is this. The responsibility only comes when you can form a government. Now, if a person comes up after the election, says that I am going to form a government, then at the national level, the person takes an oath as the Prime Minister, and then the President asks the person to prove the majority in the Lok Sabha. That is what is floor test. Similarly, such a thing can happen in the State Legislative Assembly also, where a person can come forward, the leader of the party can come forward, and he can speak to the governor that I am going to form the government. The governor can immediately sworn in as the chief minister, and then the person has to go and prove his majority. Can do it by his own political party or a coalition. Anything can happen. But a floor test is must. That whatever may be the majority, whatever may be the number of MLAs within the Legislative Assembly, the majority has to support the person who is standing for the post of the chief minister. And if this majority is not there, then it's a big problem. Then you cannot form the government. Then, a next person can be asked to come and attend the floor test, prove the majority and form the government. Whoever proves the majority. तो लोकतंत्र नंबर का गेम है. This is a very important thing which you must understand. अगर आपके पास नंबर्स हैं तभी आपकी सरकार बन पाएगी. तो उस नंबर को प्रूव करने के लिए फ्लोर टेस्ट होता है. Okay. Now Article 164 clause number 2 states mandating that the Council of Ministers shall hold office during the pleasure of the governor. And Article 75 and this is Article 74. Similar thing is said by the Union. Now what is this pleasure of the governor, the pleasure of the president? It simply means only when they can prove their majority in the house. अगर मनी बिल पास ना हो तो भी सरकार गिर जाती है. प्रेसिडेंट की जो स्पीच होती है टू द फर्स्ट लोकसभा, you know, the first speech of the president, which is of course being written by the council of minister, then it is put to vote. वहाँ पे अगर वोटिंग फेवर में नहीं होती है तो भी सरकार गिर जाती है. So there are many mechanisms where a government can fall. Okay, and it's a very important understanding about the parliamentary form of government, that it is about numbers. You have to have numbers in order to be there on the post. There has to be enough number of MLAs or enough number of MPs which has to support your claim for the chief ministerial or the prime ministerial post. There has to be a council of minister, and it's a responsible government. That is what is called the parliamentary form of government. Okay, this is how it works. So you must understand what is floor test. You must understand about Article 75 and 74, about Article 164, clause number 2. Floor test is not directly written anywhere in the constitution, but that is a term which is being given to prove the majority in the house. Opposition notice seeks removal of the chairman of Rajya Sabha. So the Vice President of India is the ex officio chairman of Rajya Sabha. Everybody have this knowledge. He is elected by both the houses of parliament. Okay, the electoral college also consists of the nominated member, which are not there in the electoral college for the election of the president. The electoral college of president is very different from the electoral college of the Vice President of India, and also the removal process is different. Now, removal of the Vice President of India can be done under Article 67B. What happens? That you have to give a 14-day prior notice and also the opportunity to the Vice President to defend himself. Once that is done, then the Rajya Sabha has to pass a resolution by the majority of the then membership of the House, whatever be the membership of the House during that time. If few seats are empty, let them remain empty. But the then membership of the House, the majority should vote in favor of the motion, and the motion is for the removal of the Vice President, or the removal of the chairman, we should say, of the Rajya Sabha. And once this motion is passed, then this motion goes to the Lok Sabha, and by a simple majority, if Lok Sabha passes the resolution, the Vice President or the chairman of the Rajya Sabha is removed. So this is the simple process which you must understand. That Lok Sabha also takes part in the removal process, not by special majority but by simple majority. And it is always the Rajya Sabha which takes the lead, the majority of the then membership of the House, who must, vote in favor of the motion for the removal of the chairman of the Rajya Sabha, and he is removed. And once the position of the chairman is emptied, the vacancy is created, the next to him, the person who has been the vice chairman of the Rajya Sabha, acts as the chairman of the House. But there is no provision given that who will become the vice president. But within 60 days, 60 days, the election to the post of the vice president has to be conducted by the Election Commission of India once the vacancy is created. So all these little provisions are very important for prelims examination. You must remember this. You must always remember this thing. So resolution by the Rajya Sabha with an effective majority, more than 50% of the total membership, and agreed to by the simple majority of the Lok Sabha. This is an important thing. A 14-day prior notice should be given. Grounds for removal are not explicitly listed. Moving on to the next topic. Again, Election Commission of India issues notices over Model Code of Conduct. What is this Model Code of Conduct? It's a very important thing. You must study. So, recognition and registration, De-recognition of the political party. So what is the difference between recognition of the political party and registration of the political party? So registration of a political party is done under the Representations of the People's Act. Okay, under the Representation of the People Act, registration of a political party is done. But the recognition is done by the Election Commission of India. There can be two kinds of recognition which can be there. One is the recognition of a party to be a state party, and other one the recognition of the party to be a national party. And there are provisions regarding declaration of a particular party to be a state party or to be a national party. So what are these? For example, if a party gets 3% vote, total vote, and some number of MLAs, let's say 6 MLAs, then the party can be declared as a state party. If it gets 6% of the vote, okay, in the legislative assembly election or in the member of parliament election, means the Lok Sabha election, then the party can be declared as a state party. And if it is recognized as a state party in 4 different states, then it can be declared as a national party also. There is also a provision that in the Lok Sabha election, if a party gets 2% seats, according to the present Lok Sabha, if they get around 11 seats, that can be declared as a national party. So this is what is called recognition and de-recognition. That is given by the Election Commission of India. Sometimes the parties who cannot perform also loses the recognition. They also loses their symbol. They also loses their name. Many times this happens. So a party has to perform, and there are also benefits if a party is recognized as a national party or as a state party. There are benefits regarding taxation. There are benefits when a star campaigner can be there, and regarding the funding of the parties. Okay, because that is a recognized party. When it comes to registration, the registration can be done. So this de-recognition can be done by Election Commission of India, but deregistration, there is no provision of deregistration by the Election Commission of India. You must understand. So if a political party has to register itself, it can register itself within 13 days of it becoming a political party. आपने एक political party बनाई, जिस दिन आपने बनाई उसके 30 दिन के अंदर तक आपको इलेक्शन कमीशन ऑफ इंडिया के पास जाके अपने आप को रजिस्टर करवाना होगा, और वो पूरी प्रोसेस होगी रिप्रेजेंटेशन ऑफ पीपल एक्ट के अकॉर्डिंग. ओके, वहाँ से आपको सारी चीज़ें जो भी प्रोसेस रहता है या जो भी चीज़ें which has to be given to the Election Commission of India will be told. Oath of allegiance to the Constitution of India has to be given by you in writing. There also has to be a constitution of the party which needs to be submitted to the Election Commission of India. That is the process of registration. Okay, the process of recognition and de-recognition is very different. The recognition can be there for national parties and state parties. There are few provisions regarding the percentage of vote you are getting, or regarding the number of seats which you are getting in the state legislative assembly and in the national election. So this is important for you to understand. Please keep this in mind for your prelims examination. So what are the benefits of recognition? A party which is a recognized party can be a state party or a national party. It has a common symbol. It has a free airtime on TV and radio. Star campaigners are allowed. 20 star campaigners are allowed. Access to electoral roll, that is also allowed. Office allotments are also there. And tax exemption. Now tax exemption is also given to unrecognized party which are registered. So to be recognized or to be unrecognized, at least you have to be registered. A party which is not registered cannot be recognized by the Election Commission of India. सबसे पहले तो आपको register करवाना होगा Election Commission के पास according to the Representation of the People Act. Moving on to the next topic. Can Indian Parliament do what South Korea Parliament did on martial law? What is martial law? Is it defined in the Constitution? So there is no definition or explanation given in the Constitution of India for martial law. So if you see the context, following the events in South Korea, discourse arose around the martial law and its provision in the Indian Constitution. If you see the Indian Constitution, martial law is a word which is inserted under Article 34 of the Constitution of India. Now if you read the text of Article 34 closely, you will understand that it nowhere explains what is martial law. It only says that if martial law is applied, there can be some restriction to the fundamental rights. Some restriction can be to the fundamental rights for a limited period can be there when the martial law is imposed. Okay, it does not define martial law as such. So, law made under this article may curtail fundamental rights temporarily, not permanently. And this martial law can be applied to the whole of the country or to a single part or to multiple parts of the country where there is disturbance or a internal rebellion kind of a thing, or there is a war or a civil war, then martial law can be applied. So in a way we can also say that Armed Force Special Power Act 1958, although it has not been categorized as a martial law, but it is similar to the martial law where power has been provided to the authorities, to the military authorities, and the power is very extensive power, even the power to shoot. Whenever they feel as if there is some threat coming or there is some threat from the person who is a civilian, they have the power to shoot also. So, okay, these kind of powers are given to the security forces, but categorically, Armed Force Special Power Act is not under the martial law. Martial law is different, okay, which is there, sort of this word is inserted under Article 34, but although not defined. So, the action must relate to maintaining or restoring of the public order, and the declaration and the scope of martial law remains undefined in the Constitution. अगर आपने उसके, you can also be indemnified. That simply means if you do something to protect the peace in the country during the martial law, then some positive things can be done for you by the parliament. That is also a provision under Article 34. If you read the text of the article, that is a very beautiful text, but it does not define anywhere what is martial law. So, okay, it is a bit different from what has happened in South Korea. Only temporarily fundamental rights can be curtailed during martial law in India. Moving on to next important topic. Citizenship Amendment Act. Rules are notified. Now, what is this Citizenship Amendment Act? So, Article 5 to 11 relates to the citizenship in the Constitution of India. That is part number 2. But whatever is written under Article 5 to Article number 11 ends and in a way is restricted till the commencement of the Constitution. So on the commencement of the Constitution, who will become the citizen of India has been told by Article 5 to Article number 11. Although the Parliament is given the power to bring a statute, to bring a law which defines the future course of citizenship in India. And in 1955, the Citizenship Act was enacted by the Parliament. That act has been amended several times. In 1985, it was amended. In 2002 also, it was amended. So recently in 2019, the Citizenship Act was amended. So Citizenship Amendment Act of 2019. It was heavily criticized. There was violence on road also. There was riots also in Delhi. What are the provisions of the Citizenship Amendment Act of 2019? That persecuted minority from 6 different religions except Islam, from 3 different countries, Afghanistan, Pakistan and Bangladesh. So persecuted minority from these three countries. And what these minorities can be? They can be Hindus, they can be Christians, they can be Sikhs, Parsis, Jains, Buddhists, these six. If they are persecuted in these three countries, Pakistan, Afghanistan and Bangladesh, they can enter India and they can get a fast track citizenship. Anybody who has entered India before 2014 December has already got the citizenship of India. But they must be from these six religions, which are minority in the three countries of Afghanistan, Pakistan and Bangladesh, and also they must show in some or the other way that they were persecuted minorities there. So the rules to implement the Citizenship Amendment Act of 2019 has been brought by the government. What are these rules? Online application is there. So a person who wants to enter India, want to become the part of India, the process of naturalization has been decreased to 5 years. Anybody who have already entered India before 2014 is already being given the citizenship. To apply for citizenship, there is an online application process. That is what is written in the rules. The next thing which is written is the district and state level committee for verification and certification. So there are two levels. The district level and the state level committees are there for verification. Whether the person who is coming belongs from the three countries or not, or belongs from the persecuted minority or not. Some kind of data has to be there, some kind of verification has to be there. That verification is done on two levels, at the district level and at the state level. Then requirement of proof of religious persecution or fear thereof. You just want to enter India and become the citizen of India, and that is the reason you have changed your religion to either Sikhism or Hinduism or any other religion, and then you enter India. Now there has to be some kind of verification. Okay, and you have to also prove that you belong to a persecuted minority. You cannot cheat the authorities by changing your religion and then coming to India and trying to become the citizen of India. That also has to be verified. So there has to be some kind of proof of religious persecution. Also, there will be verification at the state level and at the national level. The oath of allegiance to the Indian Constitution. This is very important. If you are entering in India, you want to become the citizen of India, you should show the intent to be the citizen of India, and that intention is reflected when you show your allegiance to the Constitution of India. It is very important. Citizenship certification through digital means. So the whole process has been digitalized. That is what the rules for the Citizenship Amendment Act 2019 says. They are very, very important. So the rules operationalize under Article 11, which empowers Parliament to regulate citizenship. So from Article number 5 to Article number 11, Part 2 of the Constitution of India talks about citizenship, and under Article 11 it is the Parliament which can make law on citizenship, since single citizenship is there in India. We do not have dual citizenship like the United States, where there is different citizenship. There is a national citizenship and there is a state citizenship. In India there is only one single citizenship, the Indian citizens, and the laws regarding those Indian citizenship is made by the Parliament. And Article 11 empowers the Parliament to make these laws. Okay, so Parliament to regulate citizenship. However, the implementation excludes 6th scheduled areas and inner line permit regions for the preservation of their local autonomy and culture. So this rule, these particular rules, the Amendment Act is applied to whole of India except the 6th scheduled areas and the inner line permit. Now, what is 6th schedule? So the tribal areas from 4 states, Assam, Tripura, Meghalaya and Mizoram, are covered under 6th schedule. These are the tribal areas where you will find the autonomous councils, and the autonomous councils, they govern those areas. The governor of the state holds immense power in those areas. Okay, and the CAA 2019 and the rules thereof does not implement to these 6th scheduled areas. Also to inner line permit areas. What is inner line permit? That is a kind of permit to visit that area. The inner line permit, I think, was there in Manipur, that if you have to enter that particular area, you need this permit. You cannot enter without the permit. So to protect their autonomy and to protect their culture, the CAA rules are not applied to these areas. So you can get a question in your prelims examination that CAA rules are applied to which area, which region? To the whole of India, to the whole of India except Schedule 6 areas, whole of India except Schedule 5 areas, whole of India except the inner line permit area. You have to mark this correctly, and you can only mark that correctly when you know the provisions. Provisions are very simple, that it is applied to the whole of India except the 6th scheduled areas and the inner line permit areas. Now, moving on to the next important topic. Supreme Court verdict on sub-classification of scheduled caste and scheduled tribe. We have already seen Article 341 in one of the slides that Punjab was trying to add a particular community in the list which is prepared by the President of India with the consultation of the governor and can only be amended by the Parliament. So what has happened here? Sub-classification or sub-categorization under Article 341 of the Constitution of India. It is important. So the power to make the list of the scheduled caste is given to the President. President in consultation with the governor make the list for different states. We have seen this already. Then to amend that list, the power is given to the Parliament. The state assemblies as such, the state government does not have any specific power with regard to the making of the list or amending of that list. Okay. But the recent judgment of the Supreme Court has extended this power of sub-categorization or sub-classification to the states. The Devender Singh versus the state of Punjab, this was the case, a very important case in which the sub-categorization of scheduled castes and of scheduled tribes were allowed, and Telangana recently has become the first state in the history of India to sub-classify or sub-categorize the scheduled castes. So again, trying to understand from the example of Telangana, there were 59 castes which became which formed the list or which formed the homogeneous category of scheduled castes. There were 59 castes, okay. These 59 castes were given 15% reservation, which is extended to the scheduled castes. Till here it is clear. Now, what is subcategorization is that these 59 castes which are treated as homogeneous castes, they are further divided into 3 categories. Okay. And 1% reservation is given to this category, 5% is given to the second category, and 9% is given to the third category. In this way, those which are the most marginalized and downtrodden caste among these 59 also gets the benefit of reservation. That is where the sub-classification of sub-categorization of the scheduled castes comes into play. Or there would be perpetual inequality in the society. The very purpose of the reservation would fail if the sub-categorization not there. Those were the words of the Supreme Court. So it is important to sub-categorize, and this power of sub-categorization has been given to the state government, and Telangana has become the first state to do so. Erstwhile, Andhra Pradesh has also tried it once in the year 2000. Okay, but that was overturned by the Supreme Court, but now the Supreme Court has agreed to it, agreed for the sub-classification. Now, sub-classification or sub-categorization is allowed for OBC category according to the Indra Shawnee case of 1993. There is also a provision of creamy layer in OBC, which is not found in the SCs and STs. Okay. Moving on to the next topic. Delimitation Commission, a very important thing in news nowadays. Why? Because 2026 is coming, and according to the changing population, the boundaries of the constituencies needs to be changed, and for that there has to be a delimitation commission. So if you see Article 82 of the Constitution of India, 83 of the Constitution of India, this talks about the tenure. This talks about 83 about the jurisdiction or the boundary. So after every 10 years, after the census, a delimitation commission must come into play. To understand this in a very simple word, what is delimitation? This is the simple exercise of changing the boundaries of the constituencies. The constituencies can be the constituencies for the member of parliament and the member of legislative assembly. So what does the delimitation commission do? First is, with the changing population, it changes the boundaries of the constituencies, and that has to be done according to the Constitution of India after every 10 years, after the census, because in census the population of the country is calculated, and after the calculation of the population of the country, delimitation should happen. That is the idea of fair representation. Okay, the fair representation can only happen when there is some kind of ratio which is maintained in representation. That happens through the delimitation exercise. The second important thing is the allocation of the seats. For example, the allocation of the seats in Lok Sabha from different states. That is also done on the basis of the recommendation of delimitation commission. So it is very important. So it has to be done after every 10 years. But this was freezed. Okay. The recent, the present Lok Sabha, which contains around 545 people, 543 member of legislative assemblies, that was done on the basis of 1971 census. The population of India, which was there in 1971, according to that, the boundaries of the legislative assemblies and the boundaries of the parliament, the members of the parliament, the constituencies for the members of the parliament has been made, has been drawn out by the delimitation commission based on the census of 1971. In 1976, by the 42nd Constitutional Amendment Act, which is a very important constitutional amendment act, many of the provisions which were brought by the 42nd Constitutional Amendment Act were overturned by the 44th Amendment Act in 1978. So according to 42nd Constitutional Amendment Act, the allocation of seats to the parliament has been freezed till the year 2000. And in the year 2000, it was further freezed till 2026. Now 2026 is here. We are already in 2025. So there has to be a delimitation commission, and the population has changed drastically. The recent 2011 census has to come into play, and a delimitation commission has to be established by the parliament to look into the changing of the boundaries of the constituencies for the member of parliament and for the member of the Lok Sabha. So what is happening, if you see, what has happened from 1976 or 1971 till now? The population of the northern state has increased tremendously, and the population of the southern state has been contained by them through family planning and through several policies. So, in a way, the southern states are penalized. They have followed the law, they have followed the process of family planning. They have done everything to reduce or to contain the population, and now they are being penalized. So the southern state are feeling like they have been cheated. So something has to be done, because if you compare the population of the northern Indian states such as Uttar Pradesh, which is going to get huge number of seats because of its huge population, whereas the states of Tamil Nadu and Kerala and the other southern state are not going to get that much seats, even comparatively that much seats. Why? Because of the less population, because the Delimitation Commission takes its decision to make the boundaries on the basis of the population of the state. Okay, so this is a big question which has come up again. So you must understand the basic nitty-gritty of what Delimitation Commission is under Article 82 Lok Sabha and 170 for the state legislative assemblies. So Lok Sabha election recently took place in 2024. Several things have come up. So the context of this news is that the Lok Sabha election were held amid calls for reform. Reform in nomination rules, in campaign conduct and in vote counting. तो ये मुद्दा तो बहुत पुराना चल रहा है, वीवीपैट वाला, वीवीपैट. So in one of the case, this VVPAT, it was, the petition was to implement the VVPAT throughout the country in the election. But citing some practical reasons, Supreme Court has said that VVPAT cannot be applied to the full country, to the whole country in the election process. So now it is not applied everywhere. This was basically to check whether the machine in which you cast your vote, is it working perfectly or not. So if you go and cast your vote, and if you have cast your vote to, let's say, party number A, there is party B, C, D, E, and you have given your vote to party number A, then you are going to get a slip also, the verification slip, which says that yes, the vote which I have given to party number A, the slip is the same of the party number A, not of party number B, C or D. This proves that the machine is working properly. Okay, so that is what the VVPAT was, but now it cannot be implemented throughout the country according to the ruling of the Supreme Court. So these are some articles which you should keep in mind. 324 tells the powers of the Election Commission of India. 326 talks about universal adult suffrage, that everybody above the age of 18 years and the citizen of India should be enrolled to give votes, should be enrolled in the electoral roll. Article 325 and 326. 329B we have already seen, it bars the judiciary from interfering in the election process, a very important article for the free and fair election process to take place. Some kind of institutional integrity has to be maintained, and for that reason this particular article to bar the judiciary in the election process has been implemented or has been inserted in the Constitution. The Representation of the People Act 51 for nomination, campaign and disqualification rules. So as we have already seen, the Representation of the People Act 1951 is about the election process, during the election process and after the election. And the Act, the Representation of the People Act 1950 majorly deals with issue before the election. So there are concerns and doubts in the mind of students regarding these two different act of representation. So Representation of People Act 1950 deals with all the topics which should be contained before the elections, and the Representation of the People Act 1951 deals with all the topics which should be dealt with during the election process or after the election process. So EVM machines, to check whether the EVM machine is working properly or not, VVPAT was used, but then it cannot be used throughout the country, citing the practical reason by the Supreme Court. and the model code of conduct. It's a very important thing. It is not written anywhere. It does not form the part of anything, but in a way, all the political parties sort of implement, or sort of, although it is implemented by the Election Commission of India, but the acceptance is shown by all the political party. It's the convention to show respect to the model code of conduct in India before election. It is there to regulate political behaviors during election, that all the developmental works must stop, all the freebies and other kind of gifts which the political parties give to the citizen to woo them to vote in their favor must stop during this model code of conduct. Also, the issue of simultaneous election comes into play here, because simultaneous election is going to save too much of time, because in model code of conduct too much time is wasted and the developmental work is stalled or hampered. And because of that, if the election, the assembly election and the national election takes place only once in 5 years, in that one confined period, then a lot much time and energy and money could be saved, and the developmental work could go on forever till the next period comes. So the model code of conduct is also linked with the simultaneous election process. We'll see it. Supreme Court overruled the 1967 verdict against the Aligarh Muslim University's minority tag. So Aligarh Muslim University, you must understand about this. First thing is, article number 30 gives the right to the minority to establish institution, educational institution. Okay, there are several rights which are given to the minority, the linguistic minority or the religious minority. There are two kinds of minority which are being mentioned under article 30 of the constitution, and these minority can establish the educational institutes. Okay, so Aligarh Muslim University was not a university. It had become a university in 1920, but it was established in 1875 by Sir Syed Ahmad Khan as Mohammedan Anglo-Oriental College. So this was a college. Aligarh Muslim University becomes a university in 1920 by the Aligarh Muslim University Act in 1920. In 1967, a petition was filed in the Supreme Court, and the Supreme Court ruled that it is not Aligarh Muslim University is not a minority educational institute, because it was initiated by the Aligarh Muslim University Act of 1920, Aziz Basha case. So this case has snatched the minority educational institution, minority status of Aligarh Muslim University. That happened in 1967. In 1981 again, an act was passed declaring Aligarh Muslim University as a minority educational institution. But again, a petition was filed against this act, and the Allahabad High Court has turned down its minority status. Now what happened after 1981? Recently, again a petition was filed, and this time Supreme Court has ruled over the decision or the judgment of the Allahabad High Court and the decision or the judgment of the Aziz Basha case in 1967, providing Aligarh Muslim University the minority status. There are several conditions which are also being told by the Supreme Court, and the Supreme Court also said that if an institution is initiated by the minority community, then it should get the minority status, and it is not necessary whether it is getting the statutory status by the Government Act. Still it can be called as a minority educational institution. Okay, if this particular university is initiated by the minority community. So of course Aligarh Muslim University was initiated by the minority community, minority Muslim community. It although became a central university under the AMU Act of 1920, but it does not become the ground to declare it a central university and snatch its minority status. So simply Supreme Court said that if educational institution has been established or is initiated by a minority community, it should remain a minority educational institution despite of it being given a statute or a statutory status by some act of the parliament or the state legislature. This is what is the case of Aligarh Muslim University. Article 30 is very important here. Aziz Basha case is very important here, and minority status is very important term which you should understand. There are also several benefits if an institution is a minority institution. Although under Article 29, Clause 2, there shall not be any discrimination on the basis of religion, race, caste, language for the admission of the people. Some kind of reservation is although given in the minority education institute, but that there shall not be any discrimination. So okay, students of other religion can also study in Aligarh Muslim University. When a university has a minority status, it does not mean that only the students of those community are going to study there. Okay. Moving on to the next slide. Why Bombay High Court said use of loudspeaker is not essential to religion. So essential practices, we have already seen this is one of the previous slides. Essential religious practice doctrine. This is a test which is applied to everything. It is also applied to loudspeakers. So loudspeakers have become a very important part of religion, a very important part of Hindu religion, a very important part of Muslim religion also. But is the usage of loudspeaker a essential practice, a essential religious practice or not? It is not. That is where the rule or the doctrine of essential religious practice comes into play. There has to be a test which must be applied to check whether certain practice which is done by a particular religion forms the part of the essential core practice of that religion or not. This essential practice test has been applied to animal sacrifices. It is also applied to entry of women, temple entry, and to the environment also. So Article 25 gives the right to a person to propagate, profess, practice his religion. But there are also several conditions which are applied. Condition of morality which is there, of decency which is there. Those are the reasonable restrictions. Also, there is another thing which is called as the ERP, the Essential Religious Practice Doctrine, or the test which is taken. For example, if a particular religion does not allow women to enter into temples or into dargahs, then is it the important religious practice of that particular religion or not? That is checked by the Supreme Court through this doctrine, through this test. And if it is not the religious practice, then it should not be followed. Rather, what should be followed? Civil liberty. Article 14, Article 19, Article 25. Okay. So I hope you are getting. This is the fight between fundamental rights on one hand and essential practices of religion on the other hand. You have your right under Article 25 to practice, profess, and your religion, whichever religion it is, within the confines of the law. But at the same time, if you are using loudspeakers, does that also form the part of the essential religious practices or not? And if not, then it must not be used. Why? Because it is in one or the other way infringing upon the fundamental rights of the citizens. Article 21. You have the right to sleep. That is a very important aspect of right to life and personal liberty. Existence should not be like animal or there shall not be animal existence. There has to be some kind of dignified existence, dignified life. And how can there be dignified life if you do not have the right to sleep properly? And there will not be any right to sleep if you play loudspeaker all night. Why? Because you think that it is the essential practice followed by the religion. Although the court takes the test, and if that particular practice does not pass the essential religious practice test, then the practice should be turned down. So this is the important article which you must understand for your examination. Moving on to the next, preventive detention. Now, preventive detention cannot be misused for law and order issues. That is what is said by the Supreme Court. Now, article number 22, protection against arrest and detention, that mentions preventive detention in clause number 3. Preventive detention, it is presumed or on the assumption that a person can cause harm to the law and order situation, the person is taken into custody. That is what is preventive detention. And the person can be kept in custody for about 3 months. And after 3 months, there is an advisory board which takes decision whether the person should be there in the custody or not. And if the advisory board, which consists of judges, allows the further detention of a person, then the detention can be further increased beyond 3 months. But at that time, the person has to be told the grounds on which he is arrested. He must also be given the legal representation. All these things has to be done. And while telling the or communicating the grounds or the charges on which the person is elected, or the person is detained, any sensitive information must not be given. And any law regarding preventive detention has to be made by the Parliament. So now what the code is saying here, the preventive detention amendment and judicial scrutiny highlighted concerns around misuse of preventive detention. So preventive detention is a great power in the hands of the executive to confine or arrest somebody on grounds which they not necessarily be telling to the people. But what comes into play here? Who protects the civil liberties here? It is the judiciary. So judicial review is very important in preventive detention cases. And preventive detention cases must be used justly, in a fair manner, non-arbitrary manner, because it infringes upon the liberty of the person. Think about a situation. In normal terms, if a person is arrested, immediately the person has to be told about the grounds on which the person is arrested. Immediately a legal representation has to be given. If he is taken to some XYZ place, the kins and the nearby family members has to be communicated the location where the person has been taken. Also, the person has to be presented in front of a magistrate within 24 hours. But in the case of preventive detention, none of this thing applies. So a person can practically be kept in the jail for 3 months without even telling on what charges the person is there, or without even giving the legal representation. But with different cases and the overreach of the executive on the civil liberties, the court is coming up and saying that the charges has to be communicated, the charges must be due, they must be fair, they must be non-arbitrary, and a legal representation must be given. So, in a nutshell, we can say that preventive detention should not be misused. So, right to information and the exemption. Right to information is a very important piece of legislation. It, in some or the other way, it provides the basis for good governance in the country. If you get the information of whatever is happening in the governance, what kind of expenditure is done, expenditure if done, has been done in which way, in which manner, if a tender has been given, what is the process, due process is followed or not, the planning was done correctly or not, all these things are very important to to keep a check on the executive power, to hold them accountable for whatever they are doing, the executive. It is very important. It's a very, very important piece of legislation. But several changes are made recently, such as in the data protection law. Also, an amendment was made after the Right to Privacy Act, that the name of a person, the name of the official shall not be disclosed under the Right to Information Act. For example, you make a application for something, and the time limit which is given, there's also something called Citizen Charter, which tells that a particular service has to be provided in how many days or how many months. It gives the list that this particular service will be provided in 1 day, this will be done in 1 hour, this will be done in 5 months, all these things. So if you make, for example, you make an application and your application is stuck at some place, you could practically file a right to information petition, and you can extract the information about the person who is not passing, or on whose desk your file is stuck. You can ask about the authority, the position of the authority, and the name of the authority, which the authorities have to give under the Right to Information. They were legally bound to give, but now the name will not be given. So many things have been done to the Right to Information Act, which forms the basis of the good governance in this country. So Right to Information Act of 2005 empowers citizens to access information from public authority, reinforcing transparency and accountability. So several sections are there, like section number 4, suo motu disclosure of information. So if you are going to become a civil servant tomorrow, and let's say you are a secretary of a particular department, of a particular ministry, for example, under section 4 you have to make public some information, okay, so that the number of RTIs, number of right to information petitions which are coming in, the applications which are coming in, are going to decrease. So suo motu disclosure of information is a very important part of right to information. But there are several exemptions which are also given. There are grounds given in section number 8 of this particular act. Grounds for exception, like national security. If there is some information regarding national security, it must not be disclosed. Trade secrets must not be disclosed. Personal information must not be disclosed. That's what we have seen under section 8. That earlier, when you used to ask for the name of the person who is sitting on your file, that was provided to you, but now it will not be provided. So the jurisdiction of the Right to Information Act has been further reduced. Okay. Section 24. It exempts certain intelligence and security organizations such as IB, such as RAW. Okay. The information on corruption and human right violation is allowed. This is important. Not all the information is allowed, but if information is related to corruption, information is related to human right violation, that kind of information will be allowed under RTI. Moving on, FCRA registration of 5 NGOs cancelled by Ministry of Home Affairs for violation of law. Now, Foreign Contribution Regulation Act. The act itself says foreign contribution. That simply means the contribution is coming not from within the country, but the contribution is coming from outside the country. Okay. Now, what kind of contribution can come? Contribution can come in the form of money, in the form of technology, and there can be contribution in many ways, but precisely in the form of money. To whom the contribution can come? To the civil society, to the NGOs, to civil society. Now, civil society, non-governmental organization, they form a very important part of the governance process. I am saying not governance, governance process. How? Because those civil society are the spokesperson for the rights of the people. Okay, there are several civil societies which are working in the areas of education, of health, of entrepreneurship, public safety, and women empowerment, child protection, for old people. All these civil societies are there. Think about a situation when these civil societies are getting money from some foreign country, and that foreign country is giving them money, and in return it is trying to implement its own agenda in India. Now that is illegal. And it happens that several civil societies which are getting funding from some foreign countries are also running their agenda in India. If there is some law or legislation which the parliament does not want to bring, these civil society stand up to oppose the government. Why? Because their funders which are sitting in the foreign countries are saying so. Because if that particular law or the provision of law is brought by the parliament, it is going to benefit them, the funders who are sitting outside the country. So such a thing must not happen. There shall not be any kind of manipulation of the elected government in India by some foreign country, or by some sources or funders sitting in the foreign country. So to stop that, several tests has been made. Okay, so that is what is the FCRA Act. The government suspended or cancelled licenses of several NGOs. So FCRA 2010 regulation, it regulates the foreign donation made by the foreign nationals to the civil society in India, to ensure they do not affect the internal security or the democratic governance in the country. So it mandates several things. What does it mandate? Registration and prior permission for accepting foreign fundings. That if you want some kind of foreign funding, you should take prior permission from the government, and government is going to see what kind of activity you do and who is funding you. Okay, then only you can avail that funding. Disclosure of the bank account and the utilization of the bank account. Where is your bank branch situated? Now see, in 2020, further regulations were further tightened. What happened was, the government prohibited sub-granting to other organization. That simply means, if let's say this is a organization which is getting this is the civil society which is getting foreign funding, and it gets, let's say, $10 million. It keeps $5 million and distributes other 5 to 4 other civil societies, or 4 other institutions, or 4 other NGOs. This subletting, this sort of sub-granting is not allowed. Okay? If the foreign contribution is given to this particular organization, this organization must keep it and use it for its own use, but not after. It can only happen after the government sees from where the funding is coming and where is your bank account situated. And it has also tightened this one more thing, that your bank account has to be situated in a SBI branch in New Delhi. So the government has mandated opening of the FCRA account in SBI New Delhi. So the foreign funding which is going to come to India will only come in your SBI account whose branch is there somewhere in New Delhi. After that, you can transfer, you can have multiple accounts, and you can transfer that money in those multiple accounts. But the source from where it is coming, from where the money is flowing, it should come only in one bank account. And that bank account has to be there in SBI, this is a nationalized bank, and its branch has to be there in New Delhi. Now that is further tightening of the regulation. And the expenses on the administration will be limited to 20% of the total fund. So to stop corruption, because too much money is brought, and sometimes these organizations claim that administration of these organizations take a huge amount of cost. So okay, it must not go beyond 20%. Although they claim, but that money is used somewhere else. For that reason, the government has limited the administrative expenses to only 20%. So I hope you are getting what FCRA is. Bills on simultaneous election to Lok Sabha and State Assembly. We have already seen this in the previous slide related to a model code of conduct. So simultaneous election, one nation, one election, proposes synchronized polls for Parliament and State Assembly to reduce frequent election cycles and associated costs. So several constitutional changes have to be made for simultaneous election. Article 82A has to be inserted. There is no Article 82A as of now in the Constitution, but it has to be inserted to empower the Election Commission to conduct simultaneous polls. So as already discussed before, Article 82 and 83 are very important. 83 talks about the term of Lok Sabha and also of Rajya Sabha, which is a continuous house. It does not have any term. It does not get dissolved, but 2/3 of its members get retired after a time period. But Lok Sabha, it has a time period of 5 years. This is the natural time period of Lok Sabha, which is there under Article 83. So amendment has to be made under Article 83 relating to the Lok Sabha, and under Article 172 relating to the State Legislative Assembly to define unexpired term and provide continuity. Amendment to Article 327 granting Parliament enhanced power to legislate on elections. So we have seen Article 324 to 327 talks about the elections in the country. So 327 gives the power to the Parliament to make law regarding the election process in the country. Okay, so it's a very important provision of the Constitution of India. So insertion of Article 18(2)(a), more power given to Parliament under Article 327 and more power to Election Commission after the definition of unexpired term. So for example, to make it more simple for you, let's say one election, Lok Sabha election plus the State Legislative Assembly election have taken place in month of May in 2024. Similarly, 6 months before, State Legislative Assemblies have gone for election in the year 2023 in the month of December. So these two dates are 6 months apart, but around 5 to 6 State Legislative Assembly have seen elections in the December of 2023, and around 5 to 6 Legislative Assembly have seen election along with the Lok Sabha election in the May of 2024. Okay. So 2 times model code of conduct has to be applied, 2 times the cycle of election has to be there, the electoral roll has to be adjusted, the whole Election Commission of India starts to work, so many employees, especially the teachers and other staff goes to duty. So why not all this thing can happen in one go? That all the states in India, Lok Sabha election plus all the states in India, their elections happen in one go. That is what is called one nation, one election, simultaneous election. Simultaneous election means election of Legislative Assembly and state, all these states together. So you have to go and cast your vote for member of Parliament, and at the same time you have to cast your vote for member of Legislative Assembly. So much time, energy, so much money can be saved. But to bring this law, but to bring this thing, several changes has to be made. This unexpired term has to be explained. That for the first time when such a provision has to come, okay, this 6 months have to be covered up. That the next election is going to be there in 2029. If May 2029 is taken as a date of simultaneous election, then what about these state assemblies? Because their due date for election would be somewhere in 2028 in the month of December. Will they be there for 6 more months? That is to be seen. And there are other concerns also. What if no party is able to prove its majority? What if the governor's rule, or to say the presidential rule under Article 356 is applied? All these things are major concern. Then the simultaneous election may become a failure in future. Those are the concerns. But for us, for now, it is important to understand Article 82, Article 83, Article 172 and Article 327 under Part 15 of the Constitution. 2 lakh plus nota votes in Indore. Now, none of the above option is a very important option. Many of you, I am sure, must have casted your vote on the nota. Let's say there are several names and nota comes at last. These are the names of the candidate who are fighting the election. And if you press nota, then the vote goes to nota. But it does not have any legal implication. If in any constituency, in any state legislative assembly election or a parliamentary election, nota wins, then the runner-up, the person who is second, is declared as a winner. So nota as such does not have any legal implication, which in the opinion of many people is a very bad thing. It must not happen. But several states have come up. They have shown interest, such as Maharashtra, such as Haryana, is now trying to implement nota very seriously in the local polls. State legislative assembly make rules and regulation related to the elections of panchayat and elections of municipality. So they are trying to bring nota as another candidate. So nota will be a different candidate altogether. That simply means if this candidate wins, if nota wins, then the election are going to take place again. It is going to give some authority to none of the above option. It is going to tell to the candidates that the people have chosen none of you, and you must do something that the people start to choose you rather than choosing nota over your name. So it is very important, and this kind of self-reflection must be there in political parties, it must be there in the candidates. It is starting from the local level. It's a good thing. Maybe we can see this option becoming legal, becoming impactful in the national election and in the state elections as well. Who knows? So can a candidate contest from 2 seats in Lok Sabha? Section 33, clause number 7 of the Representation of the People Act of 1951 allows for it. So you must have seen Prime Minister Narendra Modi. He fought from 2 seats in one of the Lok Sabha election, from Varanasi and from Vadodara. Rahul Gandhi, he fought from Wayanad and also from another seat of Raebareli. So a person can fight election from 2 seats, but there are criticisms related with it, because the person has to leave 1 seat and choose 1 seat. So what about the electoral viewpoint? People have given vote to that particular candidate to win. What about the decision made by the people? That is the reason why this twin election, twin candidature is criticized. And several law commission, see this law commission 170th and 255th report, and also the Election Commission of India has recommended limiting candidacy to only 1 seat. But let's say when this is going to happen. Okay, it does give some political flexibility and it is a strategic tool in uncertain constituencies. Also, important campaigners or important party leaders such as the Prime Minister himself has to be elected. So it gives a certain kind of added protection that if the person loses from one constituency, at least he wins from the other constituency. But again, there are problems. It is a burden on exchequer. It undermines the voters' mandate. Okay, it's a problem. The Kerala Centre dispute over states' borrowing powers. So state can borrow under Article 293. Under Article 292, the centre also can borrow. So what kind of borrowing can be there? So if you see Article 293, the states can borrow on their own. They can fix their limit and they can borrow on their own, keeping consolidated fund of the state as a security, as a guarantee. Okay, they can also borrow, the states can also borrow on the guarantee of the consolidated fund of India. पर अगर किसी भी तरह का बैकलॉग है, कुछ भी आपने लोन ले रखा है स्टेट ने, and there is some due which is left, then the parliament may not allow it to borrow or reduce the limit, certain limit of borrowing. So that is what was done. Dispute over tax distribution in borrowing limits. Kerala's borrowing cap under Article 293 was reduced by the central government or the parliament. So this is a very important article, 293, along with it 292, which talks about the borrowing capacity of the central government, and 293 talks about the borrowing capacity of the state government. This is a very important article. You must remember this for your upcoming examination. Tax distribution done by Finance Commission under Article 280. Article 270 allows devolution of net tax proceeds, which went up to 42%, and after the establishment of Jammu and Kashmir as the the union territory, it has reduced to 41%. You must remember, this is an important provision. New criminal laws, a paradigm shift in legal framework. If you see the erstwhile Evidence Act, the procedure code, the criminal procedure code, and the Indian Penal Code has been reenacted, has been changed a bit, and new laws giving new names, Bharati Nyaya Samhita, Bharati Nagrik Suraksha Samhita, they have been made by the parliament in 2023. So BNS has replaced IPC, Indian Penal Code. Bharati Nagrik Suraksha Samhita has replaced CRPC, and Bharatiya Saksh Samhita Adhiniyam has replaced the Indian Evidence Act. So some changes has also been done, some simplification of language has been done, categorization of offences has been done in a more nicer and a simpler manner. Along with it, emphasis on the crimes against women and children has been the center point of the new this replacement of the Indian Penal Code, which is the Bharati Nyaya Samhita. Along with it, sedition law under 142A was repealed, and it is replaced by provision on acts endangering sovereignty. Now, mob lynching and organized crime are also being recognized under the Bharati Nyaya Samhita. Separately recognized, they have been made as a distinct offense which was missing under IPC 1860. And the enhanced role of technology in investigation has been accepted. So these three important law, BNS, BNSS and Saksh Adhiniyam, in Bharatiya Saksh Adhiniyam, are the cornerstone of criminal justice system in India. They are very important law. So we have completed 25 topics. We'll be meeting again at 4 p.m. tomorrow with the remaining topics of Indian polity. Thank you very much for joining me in this class. And if you have any doubt, please write to me in the comment section. We are going to discuss about it. So thank you very much and have a nice day. Jai Hind.